Alrighty, so this is going to be a couple of videos. Diesel We the People News. Okay. Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. Be armed. Use your Second Amendment. Be armed with knowledge. Okay. And probably need to go back to this video right here. Okay. And probably a couple of other ones when I talked about how to do petitions and all that. Because this case right here is a cause and effect of the administrative branch. And everything we do is in administrative. All right, magistrates. Our criminal codes, everything. All right. When I told a while back that 90% of the laws are unlawful, that's because it's under the administrative. Let me show what I'm talking about a little bit. Find out how. So check out this video. How, right? It's all these little dot connections that's taking our rights away. That's not having oath of office. That from Congress and dedicated authority to these people that don't have an oath of office and keep them, what? Not liable. Right? So you got to use your petition to Congress and file a complaint on Congress. Petition, a redress with Congress, because all these people are violating our laws, our rights, not laws, okay, and putting them under administrative. What is administrative? Subjects, all right? When you go to work, you do something wrong, boss calls you in, he is actually doing an administrative deal. And he says, hey, knock this off, or we're going to have to let you go. Okay? He's doing this in a lower scale. But this is what they're doing to us. Exactly the same thing. Exactly. Okay? And the judge is the one that's going to say, hey, you're fired. But instead of firing you, they are putting fines on you. Okay? And, by the way, it's unconstitutional. Why? Because of Bill of Attainder. Ex post facto. That's in every state constitution and every federal constitution. What they did is slap you in the title 28 USC 3002, section A15. A corporation. Alright? I know. You guys say sovereign citizen. I didn't write the code. Okay? Not a sovereign citizen. I just read the code. Okay? They put it in there. I didn't. Okay? So let's go back and find out how this case is actually very important, right? Because it had to do with the Chevron case, people. And this was actually a big win, didn't go far enough. What do I always say? They always do a rustabout. Or they do a bypass, okay? They're going to bypass your rights by trickery of words. So they're not going all the way with it, but it did take restraints on administrative, right? And but what is that, right? Administrative state. What? All right. This is codes, rules, and regulations of the administrative, right? When they say, well, you broke a rule. You broke one of their laws, people. And you are subject to, all right, 14th Amendment. Every person, U.S. citizen, is subject to the federal government. The federal government. Not federal constitution, federal government. So all statute, codes, rules, and regulations, they are saying you are their employees and you are subject to do what they wish to you. All right. Let's go.
Tsunami of lawsuits against agencies.
Let's start all the way back. Because I did go through this. Okay. Now, let's go through the beginning so you guys understand it.
From the opinion pages of the Wall Street Journal, This is Potomac Watch.
The Supreme Court issues two big rulings reining in the administrative state, including one that abolishes a judicial doctrine known as Chevron deference. Plus, a unanimous ruling by the justices puts on hold, at least for now, Texas.
For a short instance. So if you got an acre of land, you got a puddle of water back there, EPA comes in and tells you, hey, we're going to charge you $1 million a day because you got that puddle of water back there, and it's gathering mosquitoes. So they fine you, then you take your property because you cannot afford $1 million a day. Well, that's overbroading their statutes, rules, and regulations against you. Even though you have a constitutional right to own land. What are they doing? They're going by the statute and not the Constitution, people.
Florida laws regulating social media websites. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Kim Strassel and Alicia Finley. As we round out this year's decisions in a jam-packed Supreme Court term, let's take up three cases we haven't had a chance to talk about yet, starting with Loper Bright Enterprises. This is a decision late last week, and here's the holding in the syllabus from the Supreme Court. The Administrative Procedure Act requires courts to exercise their independent judgment in deciding whether an agency has acted within its statutory authority, and courts may not defer to an agency interpretation of the law simply because a statute is ambiguous. Chevron is overruled. Kim, maybe the...
Now, listen to the key words there, right? Go back and listen to it a couple of times, right? In my other videos, what do I say? Absolute, vague, and ambiguous, absolutely. You got to put that in there. Period. And you can't have an attorney because they won't do it. Unless you pay $5,000 per minute.
Place to start is, can you give us a reminder of what Chevron deference is, or maybe rather what it was, and how big of a deal it is that Chevron deference has now fallen?
Hooray, we love that, past tense. So Chevron is a judicial doctrine. It began in 1984, and it generally holds that when a statute is ambiguous or vague or there's a gap, that judges must defer to regulators because they are the experts. And this came out of a general respect.
I'm going to pause there again. Who made them the experts? Think about that. Who made them qualified to violate your rights or say you're subject to? Who's these people? Because I don't want to see an oath of office from them. LOL.
The judiciary had for the executive branch. It started very much as relying on the executive branch as the experts when it came to facts in some of these statutory or rulemaking processes. But after Chevron, it became a deference to those agencies on questions of the law. And again, it was not even a watershed moment when it first came. A lot of people didn't even...
Don't you love how they say, the law, right? It's statutes, all right? It's not a law. It's got the force of law, but it is not law. Now, I have to beg the difference. Since it is Roman law, it would be a law, but it's not supposed to be a constitutional law in our country, so therefore it cannot be a lawful law.
Recognize it as that big of a court decision or a new doctrine. But what ended up happening, lower courts really started seizing on it. It became this whole formulated two-part test that began to guide every interaction between the judiciary and the executive branch, in particular on rulemaking issues. An entire industry of lawyers grew up around trying to interpret and bring cases based on Chevron deference. It also influenced Congress's actions in that you could easily argue that over the years, Congress has become either lazy lazy on the one hand. It's just become sloppy and not interested in writing precise statutes. Or I would argue in the case of liberal lawmakers, they purposely leave statutes extremely vague because they know that most of the regulators in Washington, D.C. believe in bigger, tougher rules. And while they might not be able to pass those through Congress, if they just leave holes in the legislation, those bureaucrats will ram Mack trucks through it and come up with the most expansive rule possible. So it had become incredibly corrosive. This is a huge victory. We can talk about the specific case that was brought up and the finding of the ruling, but overall, the end of this is remarkable. It's a big win for the separation of powers. It's a big win for putting unelected bureaucrats back in their place. And it's also a big win for average Americans because a lot of these Chevron cases ended up being brought by moneyed interests and very powerful lawyers, and it left all the rest of us uncertain about where our rights were and the stability of the legal system.
If you read the dissent by Justice Elena Kagan, dissenting on behalf of the 3 liberal justices, she makes the argument, Alicia, that this is the death of expertise in Washington, D.C., and she provides some examples of Chevron cases. This is one. Under the Endangered Species Act, the Fish and Wildlife Service must designate endangered vertebrate fish or wildlife species, including distinct population segments of those species. And then Justice Elena Kagan asks, what makes one population segment distinct from another? Must the service treat the Washington state population of western gray squirrels as distinct because it is geographically separated from other western gray squirrels? Or can the service take into account that the genetic makeup of the Washington population does not differ markedly from the rest? And
all right, so repeat that one and kind of get it over your head 3 or 4 times, okay? How is that a statute if there's like, let's just say a squirrel is endangered species, but there's 1 million squirrels in New York, but in California, there's 2, right? Well, they're endangered species in California, but overall, they're not endangered species, right? But that's what they're saying. The administrative is put it so broad that made it everywhere. And so if you got 2 squirrels on your property, you're not allowed to, have squirrel gravy. But, in New York, where there's overwhelmed with squirrels, and they need to get rid of some of them, where you can have squirrel gravy. However, due to the statute, it's just the biggest crime in New York as it is in California. That's how broad it is, basically.
Alicia, to my eye, the majority opinion by the Chief Justice, John Roberts, does a pretty good job.
Not attorney, not giving legal advice, educational purposes only, okay? As far as I know, I did not sign a borrowing contract, but, I got to say these things to cover my ass. All right, next video. Till next time. Bye, y'all.